Okay, people are still trickling in, but let's get started. I am Kimball Parker. I'm the CEO of 650. And for those of you that are hearing about 650 for the first time, we are the technology arm of the law firm Wilson Sonsini. And so it's not a stretch to say that Wilson Sonsini is one of the best law firms in the world. They helped found Google and Apple and brought them public. Same with the Twitter and Lyft and SpaceX and the best, most exciting companies in the world use Wilson Sonsini as their law firm. And so, just taking a step back, just about the law generally, in order to comply with certain laws, businesses need paperwork. They need lots of paperwork, policies, procedures, notices, contracts, and those documents need to say the right things. And if not, there can be serious consequences. And that is especially the case with privacy law and the Chinese privacy law that we're going to talk about today. So what lawyers do is they make sure that paperwork says all the right things. And so they write documents all day. That's what I used to do as an attorney. And so what we've done is work with Wilson Sonsini to teach a computer to write legal documents like the best lawyers in the world. So our products are like TurboTax, but with some of the best legal expertise in the nation behind it. And so the idea is that by automating it, we can make the law more affordable and convenient so that anyone can afford the same quality of legal help as Google, for example. And so our system can help companies write over 100 different legal documents right now. So that's a little bit about 650. Today, we're going to talk about the new privacy law out of China. So on Friday, less than a week ago, the top legislative body in China, called the Standing Committee of the National People's Congress, passed this new privacy law. And it came not completely out of nowhere, but without the warning that we would typically have for a law of this size and magnitude. So the law is called the Personal Information Protection Act, or PIPL. It's similar to the GDPR, which we'll talk about, and it goes into effect on November 1st of this year. So in just over 2 months. Now that is a lightning fast turnaround for businesses. The GDPR gave companies 2 years to comply. China is giving companies 2 months for a similar law. So we have been working nonstop since the law was passed to understand what companies need to do to comply. The Stanford, lucky for us, Stanford translated the law recently, and that's a translation we've been working off. And so in 2 weeks, we will be releasing a compliance module to help companies navigate the law. So it's an automated product. It'll ask companies the same questions that a lawyer would ask them to draft these documents. And then basically our system will take those answers and adjust the documents in the same way that a lawyer would too. And the result is basically the same documents that a Wilson Sonsini privacy attorney would create for you. And so the automated product will create all of the policies, notices, contracts, and impact assessments that companies need to comply. Basically everything that a lawyer would do for you. That material is going through right now several layers of attorney review by both Wilson Sonsini's privacy group, which we consider to be the best in the world, and we're passing it by some of the top privacy experts in China. So again, the result we think will be the best compliance documents for the PIPL on the market by a mile. And we're going to price it so that any company can afford it. The law is going to change a lot in the next several months. And actually, we'll talk a little bit about that today. Our platform is built for that. We'll keep up with the law and then push updates to your documents so that they'll never go out of date. All right, so we are already seeing some high demand for the product. If you want to get on the schedule to see the tool, you can visit 650.com/China. Again, we're looking to launch that compliance product in early September. Okay, so let's get into the content of the presentation today. I'm going to talk with you a little more about some of the basics of the law, and then you're going to hear from Marie Colbeth on the nitty-gritty details of the law. So a little about Marie. She graduated near the top of her class from one of the best law schools in the nation. She clerked for a federal circuit judge in the Fifth Circuit, which is for those of you familiar with the kind of U.S. legal system, the circuit court is right below the Supreme Court here in the nation. She's worked in private practice, and she was a professor at BYU Law School. And we poached Marie from BYU. It was one of the best decisions we ever made. It's not an exaggeration to say that Marie is one of the top privacy experts in the nation. So be prepared to be impressed from Marie. Oh, we have a question. Is she a founder? Yes, Marie is one of the founders of the company too. So yes, Marie's our resident expert and one of the founders of 650. So okay, so here we go. Let's turn to the next slide there, Ransom. Who does this law apply to? Now, it applies broadly, but there are some areas that are in flux and that are a little unclear. So there are several clear cases when it applies, and that's that first bullet point. If you handle the personal information of people inside of China, then it applies. So if you handle that information in China, then it applies. Okay, so that would be, for example, offering goods or services to people in China, or having an office in China and having employees. You know, maybe having independent contractors in China who work for you. So those kind of employment type or selling type activities are going to be pretty clearly covered by the law. Now, number two, the second bullet point there, handling the personal information of people who are inside of China, but you're handling it while outside of China. That has a few bullets of when that applies. So if the purpose is to provide goods and services to people in China, then it applies. So for example, if you have a website that's hosted in the United States, but you are intentionally making that website available to people in China, maybe you have, some text in Chinese, then, if the purpose, even though the website is hosted outside of China, if the purpose is to provide a good or service to people in China, then it applies. Analyzing or assessing activity of people in China, then it applies. And then the big catch-all, other circumstances provided by laws or administrative regulations. One question we've received and thought about with regard to this is whether a company who manufactures things in China, whether the law would apply. Now that we think is a little up in the air here. It's not clear from the current framework whether contacting companies and having them work for you inside of China, whether that counts under the first bullet. So whether that counts as collecting information in China. And so, some people have thought it clearly does apply. Other people have thought, well, maybe not. It's not clear. That is still up for debate. And I think basically, if you're a company who manufactures things in China and doesn't have any other hook, I think it depends on what your risk threshold is on this law. Now, we're going to get into this. China has some levers to pull. One of them is not allowing you to do business in China. So there's some big risks there. It just depends. Again, as you're thinking about, do I need to comply with this law? What is your risk tolerance? And so some scenarios are clearly within the law, some are not. It can get a little complicated, and we can answer some more questions about that. But it's actually, again, those gray areas are not clarified yet, and it's a little bit wait and see. So that's what it applies to. It applies broadly. If you intentionally go into China, it likely applies, so broad application. Now, this law is not like the California privacy law. There's no threshold of revenue to apply. This applies to any company of any size that meets this criteria. And actually, it applies even to nonprofits and government, some government organizations, if those government organizations deal with China. So this is broad application. Any organization that meets this criteria, no matter the size or the type of incorporation. Okay, let's go to the next slide there, Ransom. And this is the last point before we turn it over to Marie. What counts as personal information? So this is, was a big question during the GDPR and during the CCPA, California's law. The definition of personal information is very broad. Okay, it includes all kinds of information, recorded or electronic or other means that basically relate to a person. So that can be that includes their name, their email address, their physical address, their IP address. Any of that information would count as personal information, any information that can be tied back to a human. So, for the GDPR and the CCPA, we received a lot of questions saying, well, I only have their name, or I only have their name and email address. Does that count as personal information? And the answer is yes. It's a very broad definition. Basically, any information about a human applies. So again, it applies to any kind of organization, and any kind of organization that really kind of touches China, and it applies to any type really of information that relates back to a person. So this is going to apply to a lot of companies, thousands of companies, certainly probably tens of thousands or hundreds of thousands of companies in the United States. And so with that, I'm going to turn the time over to the one and only Marie Colbeth to get into the nitty-gritty of this law. So Marie, take it away.
Thanks, Kimball. So as we sort of move into this, we're going to use a lot of terminology where it'll sound a little familiar if you're familiar with GDPR from the EU or with the CCPA or some of the other new privacy laws that have been passed in the United States. But the terminology used is a little bit different, so I'll try and draw some parallels for you. One of them is right here on the slide, which is personal information handling. So we now kind of have an idea what is PI, what is personal information. In the new Chinese law, we talk about personal information handling, which is essentially what we usually will call processing. So I might use those words interchangeably today, but the processing of information, so collecting it, storing it, using it in essentially any way, transmitting it, providing it to somebody else through disclosure. These are all processing. So when we talk about personal information handlers, these are controllers, people who make decisions about what happens with the processing of personal information. So just kind of keep that in mind as we go through today's webinar. And I'm going to talk a little bit to start off about the principles that are underlying the PIPL, the new China law. The principles that underlie it are similar in a lot of ways to what we do see in Europe's GDPR. If we could advance the slide for everybody. Thanks. So again, this is just something to keep in mind as we talk about everything. The goals that are established in the law are that you need to have legality. So you have to process things based on appropriate legal reasoning. Propriety, which is an interesting one that I don't know that we've seen before. So we'll see how that gets interpreted. Necessity, again, like if you have a business reason to process something, you're more likely to be able to process it under the Chinese law, just like in Europe or California. Sincerity is one that we haven't seen before. The goal of the Chinese law, when you read a lot of the articles and other things that have come out of China recently, they're talking about the need to really crack down on consumer fraud that's happening inside of China. And so that's where we see some of these underlying principles coming from, where you might see a departure from what you've seen before in the GDPR. Openness and transparency, those are ones we've seen before. We're going to talk about having to give notice to consumers or to individuals about what you're collecting and why, and what you're going to do with it. Being responsible with the information, so we have some security requirements, quality and correctness of the information. Like with GDPR, we'll talk about having to correct information you have that may be incorrect. And then prohibited things you cannot do in processing or handling personal information in China under the new law include misleading individuals, swindling them, or engaging in coercive activities. And again, those are words we may not be as familiar with seeing in other privacy laws. I think, though, that they are, very reflective of goals of privacy laws we see in other jurisdictions, because again, the goal is always to help protect the individual against, bad actors, essentially, but also against, inadvertent actions that could expose their personal information to bad actors. So you may not be a bad actor, but you have some responsibility, to secure the information, to protect it so that bad actors can't access it. So the principles are nothing really surprising, and they're maybe phrased a little bit differently than you might have seen before, but that's sort of the underlying goal of everything we're going to talk about today, is to forward these principles. So in terms of what might happen if you don't follow the PIPL and you're covered by it, we'll talk a little bit about the enforcement that we anticipate seeing coming out of China. And in the law itself, it establishes that, the Chinese government has the ability to, bring certain corrective actions if you violate the law. And one of them is just to force you to correct. So, you're maybe processing information and you haven't established one of the proper bases, like for processing. They're like, you have to do that before you can continue processing. They can also, though, confiscate any what's called unlawful income. And so unlawful income would be income that was made through an illegal processing activity. So if you're engaged in selling, products in China, you're making income off of that, but then it's determined that you were violating the privacy law while you were processing that information. And that would be income that you would then owe under the law back to China. Suspension of service, which could be a big one if you're engaging in business in China. And then compensation to the individuals in the amount that they lost. So this is maybe more where we're looking at maybe a security breach, or if there was fraudulent activity, or if it's hard to quantify that, compensation in the amount that the company gained. And then finally, and maybe most scary, is potential criminal liability. So not just civil, but criminal liability. There's no real parameters around that in the law at this time. That's one of the things that we'll see, I think, for the regulation coming out and explaining. But at this time, it just says that, criminal liability is possible. So with that, of course, the follow-up question is, well, are there any limits on, the fiscal, the monetary fines I might be looking at? And there are some limits. So we're looking at some that are, there's two different types of violations, essentially, if we could go to the next slide. One type is simply an uncorrected violation. So just sort of like your standard, we have a problem, they told us we had a problem, we didn't fix it. With that, your fine that you're looking at is the higher of, and in all of these, it's sort of the higher of if there's a range. So up to 1 million won, potentially for the company. Or, and this is again where we see a departure from most other privacy laws that we've seen, you might also have some of your employees be found personally responsible, and they could be fined between 10,000 and 100,000 won for if they have some personal responsibility for the violations that occurred. And then we have what the law refers to as grave violations. So these are more like your flagrant, your intentional, or potentially just like maybe they weren't flagrant, maybe they weren't intentional, but they were repeated, they happened over time. For those, you could be looking at fines up to 50 million won, or 5% of your annual revenue. And then for individuals within the company who might be determined to be responsible, between 100,000 and 1 million yuan. So we're looking at some really high amounts here. And we have seen the regulators in China, they have some security and other rules already in place that they've been beginning to really push, and they have been pretty stringent with them. So we've seen some high fines coming out against some fairly well-known companies in China, including most people are familiar with the Alibaba, which provides products all over the world. So we have seen some really intense activities coming out of the Chinese regulators. And something else that is sort of an interesting note in the law, and we'll see how it's determined, is that there is provision for joint liability. So if you have a situation where you have joint controllers, you could both be found liable. And so maybe you're partnering with a controller who's maybe in China, more directly regulated in a lot of ways. And so you might think like, well, maybe I could get away with it, but your joint controller can't. And so they could find joint liability between you, charge it, and then they could come after you. So there is some potential for saying like, if you're in a joint controller position and you're thinking, well, we'll just let them take, we'll let them take the risks here. And if they're taking risks, they could still potentially come after you for a violation by your joint controller. So those are, some of the potential impacts that we're seeing. And just to give you an idea of those, I know somebody put in the chat what that looks like in US dollars. Yeah, so US dollars, 10,000 to 1 million, 100,000 to 1 million would be between 15,000 and 154,000 about. 50 million, you're looking at like about 7.7 million US dollars. So we're talking about some pretty hefty fines here. So, okay, so what do we need to do to be compliant then, so that we can avoid this type of fine? The first thing is, in addition to the principles that I laid out earlier, we also have a principle in the PIPL of data minimization. So minimizing the data that you're collecting, that you're processing, to that which you need for your purposes that you have to clearly establish. So first you have to establish the purpose. It has to be clear, and it can't be unreasonable. And we don't have any parameters around that, but I think we'll just see what we traditionally see a lot of times with reasonableness requirements, which is you can't establish a purpose that would just allow you to do anything and everything. It has to be related to the business that you're actually carrying out. It needs to be directly related. So any processing that you do needs to be directly related to the purpose you've established. And then you need to limit that collection to the smallest scope for achieving your purpose. And if you are collecting excessive personal information, that would be a violation. So to do that, you're supposed to use the method of processing that would have the smallest influence on the individual rights and interests of the individuals whose information you're processing. So again, for those who are familiar with GDPR, with Virginia's new privacy law, data minimization is really important in all of those privacy regimes. And we see it again in the Chinese regime here. So data minimization is something that will then play into the decisions you make about, for example, your legal bases for handling or processing information. And so the legal bases that they've laid out match in a lot of ways the ones that we've seen in other jurisdictions. So one of the biggest ones here is consent. One thing that's interesting, at least at this stage, is that a lot of the law is written around consent. And so I would anticipate that we'll see more reliance on consent than you see in the GDPR, where with the GDPR, relying on consent in some ways is problematic because you have to be really clear about whether there's equal bargaining power and a lot of other things to establish consent under the EU regime. At least at this point, the PIPL hasn't established those sort of like barriers around consent. They seem to really be encouraging consent to be one of the main ways that people get establish a legal basis for handling personal information. So consent, where it's necessary to fulfill a contract, where your individual that you're processing data about is an interested party to the contract, where it's necessary for human resources, so for your employees, to fulfill your statutory duties or obligations under other laws. So again, like these are things that we've all seen before. One that is written a little bit differently than what I have seen in other privacy laws is the response to public health incidents or to protect people's lives, health, or property in emergencies. And so I think it's interesting. This is sort of, a privacy law that was clearly written during the pandemic at a time when a lot of personal information is being collected all over the world, definitely in China, in order to respond to a public health emergency. So that has been very specifically written into the rule here in a way that definitely goes further than we've seen in other privacy laws. And then for public interest purposes, so for news reporting, public opinion, and other activities. So again, that one could be fairly broad. I think we'll mostly see it being used by the media and by social media platforms potentially. And then you have information that's already been disclosed. If an individual has publicly disclosed information, you are allowed to process it, but you're supposed to keep that processing reasonable. So if it goes really beyond the scope of the public situation in which they disclosed it, you might be stopped and told that that's now an unlawful use. And then just your big caveat, similar to the scope question that Kimball was talking about earlier, other circumstances as provided for by law. So we're definitely seeing a lot of language in the PIPL right now that's saying, we're going to add more to this. We're leaving it open. We're expecting to see additional changes and requirements. So because consent is the legal basis that is really focused on the most, I thought we'd spend just a minute talking about consent specifically. So you do have the requirement under the PIPL that consent be given knowingly with full information. The full information goes towards the kind of notice, if we could advance the slide, goes towards the kind of notice that you're giving individuals when you're collecting or processing their information. So we'll talk about notice as well in just a minute. But so sorry, we advanced too far. We're still on consent, thanks. Giving consent when you have full information, that the consent is voluntary, so there's no coercion involved, there's no fraud in obtaining the consent, that it's explicit, so the consent shouldn't be so generic that it's unclear what they're consenting to. And then and this is really similar to what we see in other jurisdictions, if you change the purpose, the method of processing, or the categories of personal information that you had initially disclosed to the individuals when you got their consent, then you have to reobtain consent. Individuals also retain the right to rescind their consent at any time. You have to provide them a process for doing that. So, a lot of companies at this stage have, their online portals where you can make your privacy request. This would be the kind of thing where you'd need to establish a clear process like that. And also finally, and this is one that we see echoed a few times, that you can't refuse services to people for refusing their consent unless handling that personal information is necessary to provide the service. So, if I'm a vendor, I have a storefront in China, and, I try to collect somebody's personal information and they're just trying to pay me with cash, I don't need that personal information to receive the cash from them, right? So, that's kind of like one really easy example of, what does that look like? So no refusal of services if you could provide them without handling the person's PI. And so going to this question of, okay, so what is full information when somebody's giving consent, or just generally, because even if you're processing info under one of the other legal bases like contract or, to fulfill a statutory obligation, you're still supposed to give notice. So notice under the PIPL requires that you understand who is handling your information. So they have to give you the name and the contact info of the PI handler or the controller. If we could go to the notice slide now. So you have to give them that in the notice. You also have to tell them the purpose for which you're handling or processing the data, how you're going to do that, so what your methods are. So for example, if you're using automated decision-making or some sort of AI when you're processing the info, you have to disclose that. Categories of information that you're collecting or processing, the procedures that the individuals are supposed to follow to exercise their rights regarding the information. And then if there's other legal requirements that you're subject to, again, this is one of those kind of catch-alls. If there's been changes, so if previously you gave them notice and you obtained their consent, now you're giving them new notice, you need to tell them, hey, this is different. And then disclosures that you make need to be public, convenient. They need to be able to both read and store them. So again, like if you're operating a website, it needs to be really easy to find on the website. If you have a storefront, it needs to be accessible, whether that's through, we don't have specific indication, but like in California, we see okay, if you have signage with a clear URL saying this is where the privacy notice is, if you have hard copies that people can ask for and you can give them to them if they ask, think through what that looks like, because right now we don't have a lot of explanation coming from the regulator itself telling us what that would look like. So that's sort of what the rules around notice are like right now. We expect to see more clear requirements coming in the future on that. But with all of that, one of the things you notice that you have to say is what's the contact info? how are we handling it? And that handling would include if you're having it be handled or processed by what we typically refer to as a processor. And the language in the statute calls that an entrusted person. So if you have vendors or partners that handle processing for you, and you're the controller, that processor or sub-processor would be your entrusted person. So you need to give notice to your data subjects about the use of these entrusted persons. And then your contracts with the entrusted person or your processor need to limit the handling to the purposes that you've established for processing this data. And they need to have data retention limits. So you need to put time limits on how long your processors can keep the data, and establish what types of methods they can use. So again, I'm going to keep using this example because it's an important one to this law. And if you don't want them using automated decision-making, you need to spell that out in the contract. The categories of information that will be processed under the contract and what the duties are of both parties. So one of the things that will be the duty of the controller and that the processor has to allow is some level of supervision, which could, we don't have a lot of information on what that might look like, but I would imagine what we see in other jurisdictions, right? Auditing, the ability to have them help you respond to privacy requests so that you can work together to make sure the processes are being handled correctly. If the entrusted person handles data in any way that goes beyond the contract or for their own purposes, that would be a violation of these contracts, just like we see in California with your processors or in GDPR, under the GDPR. And then if the processor wants to then entrust the data to another entrusted person, so essentially if they want to get a sub-processor, they do have to get the consent of the controller or the handler to do that. So that's really similar to what we see in other jurisdictions. Not a lot of major change there. One of the things to just think through is, at what stage is somebody an entrusted person versus another handler or controller? Because we do have that difference in liability where you might be able to have joint liability with somebody who would be treated as a joint controller. And that again goes back to the same question we see in other jurisdictions of who's making the decisions, who's able at the end of the day to control what happens with that data, and can they pull it back? If they can't pull it back from somebody, if they've essentially become an owner of the data or are able to make independent decisions, then that party is another handler. It's not an entrusted person. So we see a lot of similarities there. So I've now brought it up 2 or 3 times. So I'll talk a little bit about automated decision-making. So automated decision-making is something that you're allowed to do under the law, but it does mean that you have to meet certain requirements in order to engage in it. So with ADM, you essentially, this is referring to the activities where you would use computer programs to automatically analyze or assess the personal behaviors, the habits, the interests, the hobbies, the financial data or standing, the health, the credit, all of these different things we figure out by inputting multiple data points, right? You use, programming, you use AI, you use whatever methodology it is for you to then create some data points around what that means about the individual to create some inferences. If you're doing any of that, then you do need to pay a lot of attention to the requirements under the PIPL, because people are guaranteed transparency, fairness, and justice, which means that you have to tell them in your notice that you're engaging in this type of decision-making. But also, if somebody asks you to explain how you do it, you have to explain it. And for a lot of companies, that's problematic to think about, well, some of the way that I make this decision, is intellectual property, it's trade secrets, how we do that. So how do we think through how we comply with this law and how we also protect our trade secrets in the way that we do business? So there's definitely, some friction there that you'll be seeing if you're engaging in automated decision-making. One thing that you also need to keep in mind is you can't have really differentiated treatment between people based on price that's based on automated decision-making. One of the main reasons this is in the law is because of ride-sharing apps. In China, they've had a lot of issues with that, where they will actually analyze all the behaviors of individuals who are trying to hail ride sharing apps, and they will get different prices based on not just like, that it's surge time, or, they're in this area and want to go to that area, but based on things like, the likelihood of pay or the likelihood of a tip, or like all this different information gets put in, and then people get offered different prices. So pricing discrimination is something that is not allowed under automated decision making. So keep that in mind. And also individuals, they do have the right to basically refuse to consent to automated decision making. So if it's going to impact their rights, their livelihood, and you've engaged in automated decision making to make the decision as opposed to manual decision making where a human is involved, they can essentially object, and you would have to get the humans involved to help make that decision. So that's really similar to what we see in the GDPR as well, actually. So I did see that a question came in about aggressive enforcement, and I will say, like, we don't know yet, but in terms of all the media that's coming out of China right now, there's expectation that it will be aggressive in terms of enforcement, because they also passed a data security law that will go into effect just a little bit before the data privacy law. They've had some strong enforcement actions recently, mostly targeting tech companies, but that's sort of what's currently anticipated if you talk to commentators in China. So automated decision making allowed, but must be very clearly disclosed and can't be used for discrimination between parties. And in a lot of ways really similarly reflects what we see in other privacy regimes right now. So kind of related to automated decision making, another thing that I think a lot of individuals think about when they think about the processing of data in China is identity recognition. So there's a specific article in the law that does address this. So again, this will mostly just go to people that are on the ground in China in some way, that are either offering products there, they have business offices there that may have cameras and things placed about the premises. If you're in a public space and you're using image collection or recognition equipment, so say you're operating a manufacturing center and you have cameras inside, not in like public areas, but back in the labs or whatever, it doesn't really apply to those. But outside of the building, looking out at parking lots or sidewalks or other public spaces, then it becomes subject. Well, I should say the other one is subject to this regulation, but not the special part of it. It's subject to all the general rules about personal information. But if you're using it in public spaces, there's requirements for very clear signage. It can only be used to further public security. And then you have to have individuals consent to use it for any other purpose. So if you have the security cameras up, you're using them to monitor, for illegal activity, for the safety of your premises or whatever. But then you also think like, oh, like we could get an idea for like, how busy is foot traffic outside of our premises? What's the best time of day to, do certain activities because it's when we have the most, traffic outside the doors. That's a new purpose. And that would have to actually be consented to by all the individuals walking by. So essentially prohibited because there's just no way to make that happen, right? From a practical perspective. So keep that in mind. It's most important, I think, if you are operating premises, because it's the actual collection of the images. You may also be doing some image collection online in different ways, but again, this part of the regulation is geared towards it happening in public venues. So this might be a good time to mention that we do have a significant caveat in the law, which is, this is all about regulating the activities of private businesses and individuals and organizations. It's not really about regulating the activities of the government. There are some strictures on the government in the law, but there is a fairly government-sized loophole, which allows the government to say, if I need access to your data, I can ask you for access to your data. That's still allowed for public security or whatever other established purpose that they give. So what really will change in terms of government access to data in China under this law will be that, as private companies limit what they're gathering, that will down the line limit what the government can gather when they ask the companies for information. So that's really probably the biggest impact that companies and privacy commentators are expecting it to have on the government right now. So we just talked a little bit about cameras out in public spaces. Other information that you can process legally without consent or contract or any of the other legal bases is information that's been publicly disclosed by the individual already. So that's considered, if it was lawful. So, if somebody committed some sort of privacy violation and unlawfully disclosed the information in a public square, that wouldn't make the information free game. But if the information was disclosed by the individual, you're allowed to use it. However, if your use will have a major impact on that individual, then you have to get consent. So if you're, say, using publicly disclosed information to make an employment decision, that will have a major impact. And so you need to get their consent to using that information. So that's pretty similar to things we've seen about information sort of in the public square in the past. So nothing extremely different there. What we do have that's a little bit different, but still similar to what we've seen in the past out of other jurisdictions, is the treatment of what is referred to as sensitive information. So sensitive information under the PIPL is information that if it were leaked or used illegally could easily cause harm to the dignity of the individual or the security of their actual physical person or their property. That's more broad in a lot of ways than what we've seen as definitions of sensitive information in the past. So if you're processing any sensitive information, you can only do that for a specific purpose and with strict protection measures in place. So we've already talked about, the legal bases and all of that. You also need to, put extra security measures around the sensitive information, and you need to ensure that we'll talk in a minute about engaging in PIAs. You'll have to do that for any sensitive information where you do an impact assessment to make sure that processing this information won't negatively harm the individual. So what qualifies under that really broad definition are things that we've seen before, your biometric characteristics, your religious beliefs, your health, medical information, financial information. Individual location tracking, I think, is an interesting one. They didn't give a specific definition of that, but we've seen in other jurisdictions where that essentially comes down to if, the tracking that you're doing is within a third of a mile is kind of, then it becomes the sensitive geolocational information. And then we, again, have a special rule for minors. So in China, the age cutoff is 14. So if the child is under the age of 14, the data is automatically treated as sensitive data. Consent's going to be required. That consent will have to come from the parent or guardian, not from the child if they're under 14. So those are things to think about if the type of data that you're processing is likely to include children's data. It's going to be automatically treated as sensitive and needs to get consent from anyone to handle. If it's a minor, from their parent or guardian to handle. And so a quick caveat, cross-border handling. So these are all the things we have to do with the information. If you're at this webinar today, most likely you're part of our US or EU customer base, and you're thinking, well, I'm pulling information out of China. How do I do that? So there's a few ways, and some of them are highly unlikely. So the first is that you can pass a security assessment that's done by the Cyberspace Administration of China, which is essentially like the parent regulator in the situation. Or you can undergo a personal information protection certification from a specialized body that will be authorized by the Cyberspace Administration. Those seem very unlikely that you could, it'll take time. I'm sure that they will grant some, but it seems pretty unlikely that anybody will get one done before November 1st. The other option is to enter a contract with the receiving side who's outside of China. It meets the standard contractual language issued by the CAC. That, of course, mimics the standard contractual clauses that we see in coming out of the EU. If you're transferring, European individuals' data outside of the EU, we don't have the actual standard contracts yet, though. We're still waiting for them to issue those. So that's like the big wait and see here, that we're like, okay, we can get part of the way there, but we don't have the standard versions yet. So we're still waiting. And then they just say in accordance with other laws or regulations. So essentially, maybe you're performing some processing on Chinese data outside of China, but if the government has asked you to do it, for example, this final in accordance with other laws or regulations, that's probably what we're looking at there. There's a lot of transfers of data that happen from mainland China to Hong Kong, and at least one top Chinese expert has said that it looks like transferring information from mainland China to Hong Kong is treated as transferring it to a jurisdiction outside of the borders of China, because Hong Kong is a special administrative area, which is treated as a separate jurisdiction. So, it may be that, some of those transfers that are very common that have to occur to get certain business done, they may approve under specialized regulations that they'll issue later. So what we would call derogations in GDPR language. So so still sort of a holding pattern on how to actually legally transfer the data out of mainland China. And so just sort of, as you're doing all of this, as you're trying to transfer the data, what rights do you need to keep in mind that you have to be able to offer to the individuals whose data you're transferring or handling? And these are really similar to the ones we've seen, the right to know what you're doing with their data, the right to make decisions regarding their data, and so they can limit or refuse their consent to processing their data in certain ways. They have to be able to copy their data and transfer it if it's reasonable to another data handler. The right I mentioned earlier to correction of the data. This is the next slide, I'm sorry. And then an explanation about what it is that the personal information handler is doing with it, and what their internal rules are about how they process the data. There's a limited right to deletion. So essentially, this goes back to the data minimization principle, which is if your purpose is already achieved with processing the data, or if you can no longer achieve the purpose. For example, if it was to provide a service and you no longer provide that service, that would be an example. You have to delete that data. They have a right to have that data deleted if the retention period is over, or if they rescind their consent and then say, and now delete. Those things would all be situations where they could request that deletion of their data. So all of that is a lot. I feel like it's a little bit overwhelming, but really what it breaks into for you as a data handler or controller are really responsibilities that you already have in other jurisdictions. And so it shouldn't, if you're already compliant with GDPR, for example, it shouldn't be too large of an ask for you to implement the right policies and procedures to make this happen in China as well. So your duties as a data handler are to create an internal structure and operating procedure within your company to follow the requirements. So you have to categorize your personal information so that you can manage it appropriately and list it appropriately in your notice. You need to adopt security measures if you haven't already done so, which could be anything from encryption and de-identification, keeping in mind that anonymized data is not subject to this rule. It's treated as no longer personal information. Training your employees is specifically listed as a requirement under the law. So that's similar to GDPR, where you have that training requirement. And then getting an incident response plan in place for your security breaches that may happen, that may impact the PI. And then you're supposed to engage in audits. So even if you don't have an outside agreement where an audit is required, you are supposed to engage in audits yourself to make sure that these procedures are being followed. And with that, who will oversee those? Well, just like we see in Europe, we see that you have to appoint a representative in China if you are outside of China and you're the controller or the PI handler. That person will be responsible for matters related to the handling, so kind of overseeing that you're engaging in the right processes, and they report to the Chinese cyberspace authority and respond to them if there's a question that the authority has for your organization. So that's similar to the European representative that you have to appoint if you're outside of Europe, but you're engaged in GDPR regulated activities. And then we call it a DPO in most other jurisdictions, a data privacy officer. But sorry, we're not on that yet. In China, they're calling it a privacy information protection officer. So if you handle a lot of PI, and we don't know yet what those quantities will be, they said that the authority will identify what that quantity is for us later. If you're handling a lot of information of people in China, then you'll need a protection officer who will supervise those activities and be in charge of deciding what data protection measures you need to put in place. So really similar to what we see for DPOs under the GDPR and under the UK GDPR. So not particularly new. If you don't have someone on the ground in China to act as your representative, that person, it can be a person or it can be an entity that you appoint to act as your representative. Now we can do the impact assessment. I'm getting really close to the end of the hour. There's just so much here. I'm trying to like plow through it so that you have like the baseline understanding of everything. I was talking about this when we were talking about the sensitive personal information. So you have to do a protection impact assessment, just like you do in GDPR, if you're handling any sensitive PI. You also have to do it if you're transferring any PI out of China into another jurisdiction. Both of those would be considered situations where you have to do one of these. You have to do it if you're engaging in any automated decision-making, or if the activities you're engaging in are going to have what's referred to as a major influence on individuals. That's not defined. It's anticipated that it will be treated a lot like in other jurisdictions when we have seen, if it's going to, for example, impact their ability to get a job, get a house, engage in some like major life activities, education. Those are sort of the things that are most likely meant by this requirement to engage in a protection impact assessment. And essentially, just like when you do DPIAs for Europe, you have to decide whether your processing is legitimate. So you have your legal basis. You have to decide whether it's necessary given the purpose that you've established for processing it. You have to balance the influence that's going to have on the individual, which if it's a potentially negative one, against the reason and the benefits of engaging in the processing. You have to balance the security risks and decide at the end of the day whether the totality of the circumstances means that it's allowed to engage in that degree of risk by going forward with the processing. So that's pretty similar to what we've seen before. No major departures. There are those security requirements that are built in. And with those, you essentially have to protect, not just for sensitive data, but for all data. You need to protect against security breaches under the PIPL. So you're supposed to immediately begin to remediate if you detect a security breach or a potential security breach. Sorry, we're on the security slide. Next slide. You need to notify relevant departments and the individuals whose data is impacted of the information regarding the categories involved, the categories of PI, possible harms, what remedial measures you're taking, what, if you're in terms of when you contact the individual, what they can do to help mitigate the harm from the security breach, and how they can contact you, the data handler. One interesting caveat here is that you don't need to notify the individuals if you, as the handler, the controller, determine that you can and have effectively avoided the harms. So say the security breach is, an employee had their laptop, which had lots of PI on it. They left it on the subway, and you have the security breach, but you have remote access to the laptop. You can wipe it, you can lock it, you can encrypt it, and so the harm has been avoided. because the breach won't have any impact because the data won't be accessible. So similar again to what we've seen in other laws, except that caveat is unique in several ways. The last thing here, and this really is just for really large or tech organizations, essentially, that are referred to as platform providers. They have a lot of additional requirements that they have to meet. I don't really think this impacts anybody on the call today specifically, so I'll just let you look at the slide later. I think that overall, the takeaway here that we want to have for everyone who's thinking about how will this impact me, the takeaway is you can comply with this law. It will require, new policies and procedures getting put in place. It will require that you review your data maps if you haven't, mapped your data recently, or if you haven't mapped the data you have for people in China because it wasn't necessary before. Like, that's something that you need to engage in so you can make sure that you're compliant. End of the day, it'll have a pretty big impact. There's lots of companies engaged in business in China that are outside of China that this will impact, not just the companies that are actively stationed and based in China.
Great, Marie, incredible. I think you did that all without breathing. So
basically, yeah.
Take a deep breath there. That was a lot of information. We're going to be providing these slides to the attendees in an email after this webinar. So look for that. The slides are really substantive. Thank you, Marie. Again, if you want to learn more about how we can help you become compliant and get those policies and procedures and documentation in place, you can schedule a time to meet with us at 650.com/China. So 650.com spelled out, 650.com/China. We would love to answer any questions, but we're at the top of the hour. So we're gonna end the webinar. Thank you so much for coming. If you have any questions for us, you can email us at sales@650.com. So if you have any pressing questions and that you want Marie to address and help you with, you can email us at sales@650.com. Incredible job, Marie. Thank you very much. We're going to try to keep you at the forefront of this law as we move forward. Thank you.
Thanks, everybody.